Good morning, Andrew.
G'day, Karen. You seem a long way away.
Yeah, and I feel a bit out of place. I'm not having you around. We're going back to being in separate rooms and separate places.
Yeah, and you're not on the couch either. So, and I'm sitting up here in Townsville in 28-degree heat early in the morning, an hour earlier than it is there. 100% humidity, air conditioned bleak. Pretty good.
Oh, good. You got to enjoy the warmth and sunshine while you can, because it's still pretty cold, and winter is not. It's pretty much nearly. I feel it's here already anyway. So, how's your week been?
Well,
It's been quite an eventful week. Well, a lot to celebrate. Particularly over the last week.
Yeah, I think interesting week, isn't it? With Cultural Diversity Week in Victoria being a major sort of card for the Victorian government, and one that's sort of part of our DNA as a firm. I think it's nice to have that time to reflect, not to put cakes on the table, but to actually reflect, are we doing well? And for us, it's who we are.
There's always an occasion for cake. I wouldn't, any excuse for cake and treats.
Yeah, well, there's any excuse for cake, but I've got to be there when you have the cake, Karen. That's the problem. I'm away, all right? No cake. How's your week gone?
It's been a full week. Still traveling lots. I'll be traveling lots over the next month, really. So out to see different clients. So that's fun, but it takes a bit of energy. So I'm looking forward to the weekend and trying to recharge.
Yeah, same. I think I've been literally all over Melbourne. It's been lovely to be able to get in a car and drive. So that's been good fun. And it's great to be able to go and see people, their businesses, which is terrific. And don't worry, Karen Murphy, I just saw you there before. I'm going to be coming and visiting you very shortly. But yeah, and they're getting back on planes, being in Brisbane and Townsville for work. It's good to be getting back around Australia and meeting other Australians again. And that's a lot of fun too. So
I'm on a plane this week. Is it much of a delay at airports, Andrew? I mean, because I haven't obviously been on a plane for so long.
No, nothing at all. There's no one there, Karen. It's actually a bit distressing. You walk in and the only people getting on the plane are the people who are getting on the same plane as you.
Oh, wow.
It's
okay.
Yeah.
Good to know.
With international flights, it's very, very quiet.
All right.
Well, look, we better kick off because we are now at 9:30 Townsville time, 10:30 your time.
Yes,
let's just kick off with the new omnibus bill that's gone through federal parliament, now being passed by both houses. This is the industrial relations bill we've spoken to you about for some time. And you remember Nina published an article that gave our predictions as to what would get up and what wouldn't get up. It's really odd thing that's occurred, because things like the criminalisation of wage theft, which everybody supported, the federal government hasn't done anything with at all. So it's dropped it. So the only thing that's gone through is the casualisation provisions, which says effectively that if there's no firm advance commitment to continuing independent work, then you can be a casual employee, and regular patterns of hours are not considered as a primary indicator of that advance commitment to continued work. So the key parts coming through this legislation will be: you must put people on a casual contract, you must have an engagement process that reflects the casualised nature of it, and you can have to be very clear that it's not for indefinite work. Now that's an engagement process and a contract, which we're going to come back to everyone in the next couple of weeks. This hasn't gone off for royal assent and become law yet, but when it does, we'll do a special session on what you need around that. The government's also been very clear to say two other things. Where the awards currently allow a transition of 12 months to permanent employee and require you to go through a process, that will now extend to all employees, not just award-based employees, Karen, so all professional services, all those sort of people.
Yeah, I was going to ask, so what particular industries or sectors are exposed, Andrew?
Look, any industry which is not award covered for this particular issue, because the rest of them have the conversion clause in 12 months. But for businesses like law firms, accounting firms, IT businesses, marketing businesses, all of them who use casuals all the time need to understand the 12-month period for conversion. The other part is there is a retrospective part of it which says that no matter when you're a casual employee, any claim that tries to double dip, that is to say that you didn't pay the right amount, so you charge the hourly rate on top of it, of a casual, is cut. If you've been paid casual loading, it will be offset forever. So when you look at the cases that came through, like Risotto's case, the true loading to reflect what is casual loading would have been about 27.5%, but they were able to claim both the 27.5% and the 25%. So the two cases before the High Court, this cuts the guts out of those, cuts the guts out of the class actions, and Matt and Ness have written an article which we'll send out to you showing that the common law is not too keen on retrospective legislation. And so I suspect this particular clause that goes back in time and saying you can offset casual loading, I think that's going to be a real problem. We're going to see cases before the High Court on it pretty soon. So that's really it with the Omnibus Bill. We'll get you out exactly what's going on, and you'll get that out straight after the program today. But yeah, not what we expected. And the federal government have said in an estimates committee, they haven't given up and they're going to come back and fight for everything as well. So I don't know what's going to happen in the future and what the idea is around that. A couple of cases just to jump into as well. Qantas and Rawblack. Now, I'm not sure how to spell that, Nick, if you're the defendant in this matter, but that's how I'm going to pronounce it. Interesting case in that it's a very, very stylish case. It's about an anti-suit injunction, which I won't try and explain to you. But Rawblack was a guy who was employed by Qantas, worked in Singapore, had a Singaporean contract, where the exclusive jurisdiction clause in the contract was for Singapore. They updated his contract to include an updated contract with a deed of restraint on it, and the updated contract was a Singaporean exclusive jurisdiction. But they didn't look at the templates they're using, and the deed poll actually had Japan as the law of the restraint. He brought a claim in Singapore trying to say these were not enforceable restraints. And Qantas brought an action in the New South Wales Supreme Court saying, everyone lives in New South Wales, so the case should be heard here. And in any event, the law of this case is Japan, it's not Singapore. The New South Wales court just said, look, you're wasting our time. The clear intention of exclusive jurisdiction is Singapore. A case is being started there and we're not going to get in its road. Now, Qantas has said they'll appeal. That's not the issue. The issue to me here is how dangerous it is when you have template contracts not to read them carefully and understand what is the jurisdiction you're going to end up having a fight in. It's crazy, isn't it? Because here, if they hadn't have done this, they wouldn't have spent hundreds of thousands of dollars on this case. Qantas are going to appeal because Jetstar have stolen this guy away, all because the deed poll should have had Singapore on it. Mm-hmm. And instead they made a mistake and had Japan on it.
Yeah, look, that's the danger with that's the danger in using templates, and particularly when it comes to recruitment and there's a rush to get somebody appointed, you underestimate the impact of getting those details wrong. Jurisdiction, you'd think you kind of cast your eye through and you should be okay, but for a large organisation or where you're operating across various different jurisdictions, or it's a large organisation, really, you need to spend the time checking over and making sure that the context is right.
Yeah, and look, if you're an Australian-wide company and you were going to have a restraint in the contract, you definitely have the exclusive jurisdiction in New South Wales because it's the only jurisdiction that has a restraint of trade piece of legislation that allows you to read down the restraint to enforce it, whereas everywhere else in Australia is common law. So you can pick your jurisdiction for restraints if you're an Australian-wide business, and you should. You absolutely should. Anyway, look, that's enough of that case. It's just a really interesting case, and it just reminded me as I read it. Case sounds very, very, very exciting, anti-suit case, but I said suitcase. That was very good. I didn't even mean to say that. But the real issue here is the risk of templates. The next case is a really dumb case, and it's a case called D'Souza, who worked for a supermarket. She behaved badly, was rude at times. In fact, quite rude at times to a manager, but her manager's response always escalated and inflamed and reached the stage where his behaviour towards her was bullying. And D'Souza brought a anti-bullying application and eventually achieved orders, or actually the commissioner intervened and said, look, you need to go and work somewhere else. D'Souza, she'd not wanted to do that. But they got the commissioner involved in running their business as to who works where, all because the manager failed a performance manager. Instead of performance manager, he yelled, shouted, was abusive and offensive. Dumb, 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 dumber. all she had to do was be managed correctly. And they end up in anti-bullying getting the commissioner working out how to manage your allocation of staff in the supermarket. What do you reckon about that?
Oh, it's madness. I mean, yeah. Well, performance management, again, underestimating the importance of taking action quickly as well, Andrew, because we could sit here and talk about, yeah, we should probably do something about managing this person. Just do something. Like, you've got to be prompt. Otherwise, every day that carries on just creates a greater risk to you.
It is that, isn't it, Karen? Because you're looking at a person who's rude. Now, it's not hard, is it? What is the purpose of my business? The purpose of my business in a supermarket is to provide seamless service to customers for day-to-day products they wish to buy. So having one of your employees being rude around the vicinity where customers is clearly a breach of purpose, okay? Because it affects the capacity and the environment. But in values terms, if I'm rude to you, you have to say to me, Andrew, when you said that shows, under our commitments, which we call our values, you'd say straight away, look, Andrew, when you speak to me, that's not respectful. And I want it to stop. Now, if you were my manager, you probably do that and you say, look, Andrew, can I have a chat with you? Sit somewhere privately and go, look, you said this to me before. This is what we expect under our values. Remember the 5 aspects of counselling. This is what you did. This is what you're meant to do. Is there a reason why you don't do it again? And I'm going to follow you up. They're the 5 elements of any counselling. It might be because I didn't like the way I looked at you. I don't know. But the bottom line is you've got to give 2 lawful and reasonable directions. This is what our values are, and don't do it again. None of that happened. And we end up, again, thousands of dollars later, disruption in your organisation, and then the commissioner coming in and deciding where people work.
Yeah.
How crazy is that?
It's crazy. And like the point, adding to your point there, I reinforce again the importance of acting on it really quickly, because the longer, if something had occurred, the longer you leave it, you're just diluting the importance of your intended message. And
people are sort of into then limbic overload, aren't they? They've got that fight-flight thing. You start to feel conflict, and then it becomes harder and harder to have the conversation. Now, look, we're over to that very special part of the program for which we don't have a name at the moment, but maybe yes. Karen's Corner.
We've received a couple of suggestions. I'm still trying to nut it out. So thanks for those. Thanks to everyone.
Yeah, we want more suggestions because my idea of Karen's Corner has taken a lot of flack. I think the commission would have been glad they went to university for so many years just to actually, I think you're right, Jane. I think you're absolutely right. Okay, Karen, into your corner. What are we doing?
To my corner. Here we go again. All right. So, look, capability. Ooh, Sophie's loading up the screen for me.
Yeah,
so,
Andrew's there you go. Peter, thank you.
Last week we mentioned that I was going to put something together around capability and mapping. And what I've got here, we've sent something out this morning around just some fundamentals in terms of the elements that you need to consider in terms of creating a sound capability matrix. Now, just a bit of context around this. Capability matrix, like a capability mapping exercise, would be extremely valuable to you throughout a restructure process. It can actually be used much more broadly. So particularly from businesses right now who are thinking, well, what's our business requirements? How do we need to change? If you're thinking about changing roles or changing the structure of your workforce, these are good tools. This is a good tool to have to actually assess what, I guess, your human capital in terms of where it's at, where it needs to go, identifying that gap. But for today, and this tool alone is around the restructure redundancy topic. So look, when doing this, there is no, I've been asked before, is there a template that you can use? Is there something special that you have to create? Look, it's not, you can create your own table. Okay, so that in itself is not difficult to do. The part that's important is making sure that it has the following things. Firstly, ask yourself the question in terms of why you're actually doing it. What's the purpose of this matrix? That will then help you craft how to structure that tool. So very important is around the criteria, okay, being very objective around what's important for the job. It should be measurable and accessible and to be done easily so that it's easy to compare against, this person versus that person, whether or not overall their skill base and capability is stronger or not. So that subjectivity, if we can keep that at bay or minimize that as much as possible, that's where we want to get to. Ensuring that making sure that we've got the right people involved as well is really important. Sometimes it's just thrown over to your HR person to do all their own. on their own. It's really a piece that involves the managers in terms of who oversee that role. Getting input also from people around what the job entails, because although position descriptions are a fantastic reference point, they often don't capture elements that, parts of it that, I guess, tasks and responsibilities that have been emergent in more recent times, or certainly in terms of what might be relevant in future.
Karen, can I just step back just a fraction? Because I think one of the issues with all these matrices you develop is an importance for embedding particular assumptions around weights. So what weight do I add to a particular characteristic? And can I just say to you that the most important document that sits behind all of this is your business plan, because that tells you what is the weighting that you're going to apply for those emergent positions that you're looking for. So when you create a matrix, make sure you identify in the weighting process what is the assumption and write it down so that you can defend it. You can go, yeah, well, look, we do need greater flexibility, and this person has these different attributes. Why is flexibility so important? Because of these 3 or 4 reasons. So always write out your assumptions before you start and make sure they objectively support the weighting. Sorry, Karen, I come across.
No, that's okay. And another example of that, Andrew, would be, for example, if there's a real digital or, in terms of technology transformation occurring throughout the business, and you've got a particular job or a work group that does require to be part of that journey, and that's quite significant by way of change, but that's an important feature of future roles. That's something that's underpinned by a business case and the direction of where your organisation's going. Look, I think the last part of it really is, when doing this, always seek advice. So whether that's in-house HR, just to make sure that whatever I know HR is often involved, but and if it's HR, if you're unsure, seek the advice to see, look, is this sound? Does this capture? Is this doing exactly what I needed to do to support the business throughout this restructure process? So I hope that a little tool and a couple of pointers to help you guys if you're going through this process.
And always remember, HR are the people who design capability within the organisation. They're the architects of capability, so to include them at the end is dumb. They should be front-ended. All right, well, let's jump on. Thanks very much, Karen. That's great, and it flows right into what we're doing next, which is looking at, we're going to finish, this is the second part of our restructuring. We're going to build into this. Last week we talked about what we do beforehand. Now we're going to do what happens the moment we start doing it. So we've made our definite decision, okay? The definite decision is we're going to do a restructure. What I want you to do is to create a slideshow, letters and scripts that go behind exactly what we're going to do. The slideshow should be for everybody. It's a town hall meeting. And it should show what is the intention of the restructure, how will it advance the business, and why is it essential for the business, how it will impact different parts of the business. And then it should actually go into organisational structures that show the areas that will be affected, not with names on it if you can avoid it, please, so that people can actually see across the business how the change will be affected. And the last slide should be what it looks like at the end, because when you start this process, your most important stakeholders are the people who are staying behind, okay? They must feel safe in this process, and they must feel the process is inherently fair and reasonable. The comms process is all about saying we made this decision for this reason to get this outcome, and it will impact you, and we're sorry that there are people who are going to be impacted, but it is a necessary part for the business. So one slideshow, then we go into what Deacon's case is about, which is the Commission of Business decision, a somewhat contentious decision nonetheless, which says when we go out to consult with people, we don't only consult with the areas that are definitely going to be affected, we consult more broadly. Commission of Business view is other people may be willing to make adjustments to support these people who are going, I think it's not a great decision. I think it'll ultimately be defeated by a full bench, but at the moment it is probably the law. So remember, you don't only consult in the affected area, you consult more broadly, but you then drill down with the next level of consultation to who are the affected people. You have individual meetings with them, you set out why you're doing it in a letter, they need a letter. And as you'll see when we go into the awards, there needs to be notification going out, notification to their representatives, it needs to be in writing, it needs to show what efforts are being made to mitigate the impact on people, okay? These are all the things you think about in the pre-document process, but flow through the consultation process. And of course, if you don't consult properly in accordance with what the law is, and it's set out in all the major change clauses, remember in the awards, there are two different provisions that deal with redundancy and restructure. There is the redundancy part of it, but redundancy is also part of major change. Please read it carefully, set up a tick list of what you have to do and make sure you do it. If you don't consult, it's not a genuine redundancy and therefore it does fall into the unfair dismissal regime. The time for consultation, who knows how long that is. What we know generally is the Commission will look at a period of around about 2 weeks as being reasonable from start to conclusion. You can certainly compact that if there was a compelling and necessary reason. Around the pandemic, we certainly at times conflated that time right down to a very narrow period because we had to make the change almost immediately. But when you do that, remember you're flicking the switch on what is a genuine redundancy. The other part is always have a look at what your dispute clause is, because if your dispute clause has a status quo provision, that means if it's put in dispute, you can't change things, then you need to think strategically about how fast you do this. You may do it much faster if you have a status quo clause because you've got to get it from start to finish to make sure that a dispute can't be entered into by you. The last part, I guess, to me is the most important. You must always look after those who are staying behind, and they must see that this is the last shop. Too often redundancies are done in little bits and pieces, and nobody knows whether they're next. And as a result of that, everyone drops off in their productivity. They go into hiding. They're very cautious. They're not innovative. They're not driving your business. Please do this in one thorough go and do it carefully and make sure you embrace those who remain behind. And those who remain behind, look back at the process you've gone through and know, A, it's lawful, and B, it was incredibly fair in the manner in which it's done. So that's my take on the last part of restructuring. By the way, next week is Easter, I should say that to you. But the week after that, Karen and I are starting on a 2, maybe 3-part series around managing mental health, because we think that's the largest issue that's coming out when we're in workplaces at the moment. So this is the last part of restructure, but not next week, but the week after we'll be moving into doing mental health. So Karen, we'll move now to the problem, I think. And I might get you to actually read the problem because your face is in the middle of my problem.
Okay, all right, sure. So let me go here. So the case study today, David is a graduate lawyer. His boss, Gina, is a partner. On 3 occasions, David delivered work late and not what Gina wanted. On each occasion, she was progressively ruder. On the first occasion, Gina considered that David had failed her. She emailed her team saying David has caused the project to be delivered late and pointing to the learning we must hit deadlines. On the second occasion, on a Zoom meeting, she called him a fool in front of the entire team and told him to smarten up. Her look on that occasion was both angry and condescending. On the last occasion, she said on a Zoom call, "What university did you go to? Any idiot could have done this." The other team members chuckled awkwardly. On each occasion, David tried to explain he was struggling to get sufficient certainty from her as to what she wants, and she's never there when he comes for help. Gina has been working from home, but has started to increase her hours at work. Okay, David's other team members have commented that he's more withdrawn, seems sad, and his appearance has changed. He seems less caring around his personal appearance and hygiene. David saw his psychologist, who wrote a note to the HR department noting David suffered from depression and is being bullied. HR set out steps to protect David in the environment, include change reporting and physical separation. David made a bullying complaint and an investigation commenced, but he was also becoming difficult. He was reassigned to work under a different partner, but works on the same floor as Gina. When he sees Gina, he loudly says, "She has destroyed my life. Don't let her do it to you." He now seeks an anti-bullying order and has put in a workers' compensation claim for stress. He's no longer at work. Ooh,
there you go. Well done, Karen. So it's poll time. So let's hit the poll.
We're still working on that background music, Andrew.
Yeah, no, we need the background. Soph just won't do it for us. We've tried so hard. Not much movement at the station yet.
All right, people are thinking.
There we go.
All right, so we've got 15 seconds left. Most people are coming through. All right. Another 5 to go, and we'll close it off and we'll talk about the results. 4, 3, 2, 1. All right. Thank you, everybody. Let's share the results.
All right. Well, this is interesting. So let's talk about an anti-bullying order. What is bullying? It's repetitive conduct that is objectively unlawful in that it hurts, humiliates, intimidates, and affects somebody's safety at work. So has Gina been guilty of bullying? The answer is yes. So the first part of the bullying order is up. Has there been bullying? The jurisdictional barriers to making an order are, if bullying could no longer occur, you can't get a bullying order. Well, at the moment, he's no longer at work. So the answer is no, you would not get a bullying order because he's not at work. Okay? It would depend on what the medical certificate says, but if he's put in a workers' comp claim, I'd suspect he's not coming back, so you wouldn't get a bullying order. But on the basis that he was at work, so let's keep playing that out, yes, you could get a bullying order. So the next thing is an investigation is being undertaken. An order wouldn't be made immediately. They'd wait for the outcome of the investigation to determine whether bullying had occurred, because that's a lawful process that's undertaken. And that's where you'd be. So really interesting, the fact that all of you has skirted around and weren't sure, that's a very good indication of what would occur. But when a person is no longer exposed to the bullying, then you can't get a bullying order. So interesting question. That's a legal question, not a factual question. Was Gina in breach of safety law? Well, on 2 levels. 1, provide an unsafe place of work. Okay. And secondly, failed to monitor his health, didn't they? He was clearly demonstrating what Birkin's son called, and all those cases talk about, which is this reduction in his mental health status, which a reasonable person would observe. And they failed to monitor his health as well. So they're guilty on 2 levels, both the organisation and Gina on her own personal level, which in Victoria would be section 25, failing to exercise reasonable care to prevent injury to the health of another person. So yes, she's personally liable. Let's go on to workers' compensation. I can't see what's said here. How do we go with that? Can we roll that up a little bit so I can see?
Let's see.
I do that. Maybe I can do that.
I think you've got to roll your own screen.
I've got to use technology. Those dinosaur hoofs just landed. Okay. Will David's workers' compensation claim succeed? Let's go to what could happen. Does he have a mental health issue? Let's assume he does. Okay. Did that mental health issue arise out of work? Yes. Was the things that occurred part of reasonable management action? Because that is a total defence. And the answer is no, it wasn't reasonable management action. So what Gina did wasn't a fair method of dealing with something that was wrong, and it wasn't dealt with fairly. They're the 2 tests of reasonable management action. So there is absolutely no doubt at all that his claim will succeed. Douglasaurus, thanks very much for that, Joe. You're not the first person in my firm to call me that. So that's very interesting. Claim's going to succeed, so it'll be accepted. But the next question is there any legal process for terminating that claim? And there's a case called Kerridge. And the mistake that was made in this case with David is there should have been very real physical separation between the 2. It was good that somebody else was appointed. But if they said to David now, look, David, we're happy for you to work from home on the days that Gina's at work, which we could do, it's a law firm, then there would be complete physical separation and there would be no proper basis for him to continue his claim. If his psychological claim was, I can't work near Gina because Gina drives me crazy and hurts me, if that's the basis of the claim, and he has no way of being involved with Gina, then we'd be able to terminate the claim under Kerridge. And that's why I always want you to think, particularly around bullying, it is the way you separate and keep people safe based on the nature of the claim that is made. And the claims in bullying are almost always directed at a person, okay? So if you separate that person away, you provide a safe place and support, and the person would be psychologically safe without them, then you can terminate the claim. Now, often in the middle of these claims, the Davids of the world can become very difficult people as well. They've started an investigation, they've had a circumstance investigator agree with them in their workers' compensation claim. They're starting to feel not only have they been wronged, but they have a legitimate voice in actually becoming more and more difficult in the process. So it gets very muddy and difficult, but carriage still works, okay? You need to speak to Kim when you do that, because that's Kim's area of expertise in doing it. But I do want you to remember, just because a workers' comp claim, stress claim has been accepted, doesn't mean it can't be terminated at a later time. It takes a bit of care, but it can be done. And look, the other part to remember is when 13% of all claims made across Australia are stress-based claims, they represent 25% of total claims costs. You recognise that when someone goes on stress, the likelihood of them returning to work is slim. Our obligation is to get them back, but in bullying cases, they're easier cases to fix than most stress-based claims because there is a focus on a person treating someone poorly. So
yes, that's also, but on the basis that you actually manage it actively, though, Andrew, which is why, in terms of, I was thinking the same, like Kim, who helps so many of our clients in this space, it is very involved. You need to manage it closely, get advice on it.
all right, so look, I think we can bring that. I've deleted it on my screen. I'm not sure if you've deleted it on your screen.
No,
I
okay.
think just in the last minute or so before we jump off, I do really want to talk about mental health. In fact, that's what I'm doing here in Townsville to this conference, is talking about injury management around mental health. And so not next week, but the week after that, we'll look in the first episode about what are the causative factors behind mental health in the workplace. We talk a lot about the other end of it, but we forget to look at what actually drives mental health issues in our workplace. So not next week, the week after that, we'll focus on the cause elements around it. But that's it for me. I'm off to go and speak in another venue now.
All right, excellent. Well, have fun with that, and it'll be nice to take a break. And wishing everyone Easter's started. Oh my gosh, it hasn't really landed for me yet, but
No. I've already been eating the buns for 4 weeks. Okay, Joe, thanks very much. See you later, Karen.
All right,
Karen and Matt and everyone else.
Right.
See you later. Bye-bye.
Bye now.